Oh look, Mom, I got an email. In the Reno versus the ACLU case, or the American Civil Liberties Union, the petitioner was Janet Reno, a U.S. Attorney General who represented the U.S. government, and the respondent was the ACLU. The claim was that a federal district court erred in finding two provisions of the Communications Decency Act of 1996 unconstitutional under the First Amendment. The place where this occurred was Washington, D.C., June 26, 1997, topic being civil liberties. Arguments for this case by the ACLU were that online communication differed from broadcasting and should be subject to less regulation, and that the two regulations the CDA tried to pass were too vague. Reno argued that this was the best way to attempt explicit material on the internet, either from minors receiving or people sending out to minors. This was the first landmark case also about the internet. The decision of the case was the provisions of the Communications Decency Act prohibited indecent transmissions and patently offensive displays are unconstitutional because they abridge the freedom of speech protected by the First Amendment, meaning that what we showed is legal. Get the mail! Oh my God! What is this?
In the court case Miller versus California, Miller was the appellant and California was the appealee. Miller claimed that the state of California's definition of obscenity was conflicted with that set forth by the U.S. Supreme Court. So in this civil liberties case, he took it to the Supreme Court in Washington, D.C. in June of 1973. Miller's argument was the jury's decision did not reflect the law on which obscenity was judged, and California stuck with their claim that the materials were too obscene for the general public. The Supreme Court then upheld the lower court's decision, thus proving Miller guilty.
All right, check it. The U.S. challenged the New York Times in 1971 over the publishing of the Pentagon Papers. These papers were published during the Vietnam War. The U.S. was against the publishing of these papers as they revealed vital information of the U.S. Army in Vietnam, and it really hindered their war effort. So, in 1971, the District Court Judge Murray decided not to issue an injunction on the New York Times and allowed the publishing of these papers to happen without really any type of reprimands against the papers. However, this also progressed to the Supreme Court. The Supreme Court also decided this on a 6-3 vote in 1971. So, why this makes this a major case? Listen up, boys and girls, listen up. This is the first time in 182 years that anybody has ever said that you might not be able to publish whatever you want in papers or say whatever you want. Bonus material. Ellsberg and Russo, the workers for the New York Times that achieved this information from the CIA, did this illegally. Alright, so the charges were dismissed for several reasons. That the government actually did quite a bit of espionage in order to actually really prove that they actually spied against. It was just double. They were going against each other. They spied against each other, so there was no argument for the U.S. against them. And the Watergate also happened at this time, which stole away a big part of the spotlight. So this is also a part of civil liberties, as it pertained to the First Amendment. Okay, the U.S. argument for this was that the New York Times could not publish whatever they wanted if it hindered the war effort or compromised national security. The New York Times obviously pointed to the First Amendment as their argument, and they could publish or say whatever they will.
Golly! Jesus Christ, curse the North! Kill every one of them soldiers!
So kids, in 1964, the New York Times had an ad taken out in their paper that was not only offensive to the city of Alabama and Montgomery, but to the whole state in itself. There was a citizen in Alabama that took great offense to this, and he decided to sue the New York Times. The state of Alabama decided to reward this citizen $100,000 for his complaint. New York Times took this to the Supreme Court, and eventually that was reversed. This is the first time that the U.S. government limited the state's rights to award liable damages. And that is why this case is important. So, the argument for the New York Times in this was that they could publish whatever they wanted, even though it wasn't even their opinion in the first place. And Sullivan was just offended by this, so he said that it violated his personal space. Their rights touched his nose, as Ms. Russo would say. These court proceedings took place in Washington, D.C., in the Supreme Court, and in Alabama for the previous court case that awarded Sullivan this money in the first place. This is a civil liberties issue as it pertained to the First Amendment and freedom of speech and freedom of press.